or chat. And Laura Pereira is also my associate. She's also there to help and can maybe help me manage the chat in case I'm missing anything. Okay. Well, it's a pleasure to sort of meet everybody. And we're going to get started. I'm going to share the screen so that you can see sort of the presentation that we have in mind together at the same time. If you give me a moment. Okay, here we go. Okay, hopefully the technical gremlins do not wreak any havoc today. So basically, we're here today to talk a little bit about what every employer needs to know. This is a very, very important topic. Very often there are, employers are just unaware. They go about sort of their business and daily lives, doing business, building their businesses, selling their products, building employees and so forth. And they actually do not take the time or have the knowledge to understand actually how intricate employment law can be and some of the basic things that they should be doing on a daily basis, so to speak, and sometimes on an annually basis. So this webinar is about helping educate, business owners about what they should do and what they need to know. It is a general overview of the basic necessities, sort of an essential things that to discuss. As with anything, and as a disclosure indicates, the webinar serves as general information, not specific advice to any particular company or circumstances. For that, we do recommend that you seek advice of an attorney if you have anything specific sort of to deal with, so the attorney can properly analyze your particular situation. So we're going next to basically, we're going to start with necessary forms. I-9s and W-4s and W-9s. Oh my, as my my office manager added. Next topic is going to be wages, compensation, improper classifications, and employees and time and employee record keeping. And then we're going to go on to employment agreements and policies, and then next followed by compliance and mitigating liabilities and risks, followed by closing summary and questions and answers. So let's start off here first with the I-9, W-4, and W-9. The I-9 is required to form for any employee that you hire, whether they're citizens or non-citizens. It's basically the form that determines their eligibility to work and their permission to work in the United States. So it is very important to have it, and we're going to talk a little bit further down on why you even have to keep it on record. This is something that the federal agencies, different federal agencies, including the Department of Labor and NICE, can come in and ask you questions and ask to see these documents, and you must have them on hand within the employee record and files, so forth. So I-9 is for every employee. It is not for independent contractors. That is solely W-9 forms, okay? W-4s, as you may all know, is actually for your actual employees so that they can indicate what kind of withholdings they would like in their paychecks. And ultimately, so that this produces a W-2 at the end of the year. It's very important that employers do not discriminate against any individual, whether actual or perceived discrimination against anyone's employee, whether the citizens or non-citizens, natural origins, discriminated based on their natural origin, citizenship, or immigration status. This is pursuant to the Immigration Reform and Control Act of 1986. There is actually an anti-discriminatory agency in place that will prosecute these cases if there has been any discrimination. Again, it's actual or perceived, so you have to keep in mind you're not allowed to discriminate against anybody that might be, seeking to be employed with you based on the information they may give in the I-9. The I-9, it's not actually indicated here, but it's also going to request a certain amount of documentation. It sort of has an A list and a B list, depending on the circumstances of the employee. And the employer is required to have those specific documents that are requested in each section, depending on the circumstances of the employee. You actually must look at an original, also document. You're not allowed to initially look at a photocopy, although you can have a photocopy on file for your employment records. But it is important that you actually see the original so that you can indicate that you've assessed the veracity, the credibility of the document that's being produced to you. One other thing, most people collect this information and then they forget to verify that the individuals are eligible. the actual employee is eligible. So there's a couple ways to do that. They would need to, make sure their visa, work permissions are proper. Or of course, if they're a US citizen, there's not going to be an issue. I'm sorry, we're gonna just take a moment. Apparently there's other people that wanna come in. Let me stop the screen share for one moment to let them in because it won't let me do it from this screen. So, okay. Wonderful. So we're just gonna let a couple more people in. Thank you for your patience in letting us do this. I'm going to go ahead and reshare the screen one more time so we can pick up where we left off. Okay, wonderful. So there's a couple ways, of course, verifying the eligibility. You have to make sure that the employee's documents or visa, work permit and visa documents permit them to work. But another way of also doing this is submitting it through the E-Verify program that the federal government has. And that will give you receipt and acknowledgement forms of the person's eligibility, which is, of course, usually sort of the best case scenario that you want for your employment file. Also, do not forget about how long you're supposed to keep these files. It's very, very important to keep these documentations for a certain amount of time as required by the Act. So in other words, to determine the amount of time in which you have to keep the employee's documents, the employer is to use a date that the employee actually, the last day of in which the employee actually worked. So if calculating from the date in which the employee last worked, if the employee worked for the company for less than 2 years, the company should retain the employee's forms for 3 years after the date in which the employee first started his or her employment. So basically the first day on which they started working for the company. If the employee worked for the company for more than 2 years, the company should retain the employee's forms 1 year after the date in which the employee stopped working for the employer. So these are sort of important, tools and things you have to remember. Every employer needs to do this. We mentioned the W-9 here just to talk, to remind you that independent contractors also need to fill out W-9s. Keep in mind that although they fill out a W-9, it does not mean that they're actually properly classified as an independent contractor, which is something we'll discuss a little bit further in the presentation. So next, we're going to talk about wages and proper classifications of employees and time and employee record keeping. This is also a very crucial part of employment law, and it leads to very expensive litigation and problems for employers. Often it could almost be, a death knell to it, unfortunately, if a company is not careful with what's going on here. With improperly classifying their employees and timekeeping records. So we're going to go a little bit into the first slide, which talks about improper wage and salary exemptions. So we're going to start off with non-exempt employees. Most people know what non-exempt employees are, but it's always good to remind us of the distinct classifications and what separates non-exempt from exempt. So non-exempt employees are mostly employees that are paid most employees. They're paid hourly and they're paid overtime if they've worked more than 40 hours in any given work week. Employers need to also check with local, state, and federal laws every year annually to check for any changes in the minimum wage, not just the federal minimum wage, but of course the state minimum wage. Normally the state's minimum wage will incorporate the federals, and they're usually higher than the federal minimum wage. Currently, Florida minimum wage law requires employees to be paid a minimum of $8.65 per hour. If you'll notice in the second point, there are future changes that have already been adopted by Florida to increase the minimum wage over a period of time through 2026, various times each year, including a second change at the end towards September 30th of this year to take us down to $10 per hour. But keep in mind that by September 30th, 2026, the minimum wage in Florida is going to be $15 per hour. Okay, something that employers need to know to start planning and making sure they are properly paying their employees, because this is a source for great litigation and very expensive litigation. It has actually relatively little defenses too, which I'll talk a little bit more about when we talk about mitigating risks. Finally, the employers annually should also be checking to make sure there's no additional changes in any Department of Labor opinions as to maybe how to calculate compensatable time, how to decide how to enforce basically determine benefits, what's proper deduction from benefits, particularly exempt employees cannot be, their paid time off can, there's actually specific rules in which you're only allowed to deduct from, exempt employees paid time off. And this changes every so often. So this is something you want to keep in mind of. Like, for instance, there's also the new guidelines that are continuously coming out and opinions from the Department of Labor that help employers and help employment lawyers sort of define things, help us kind of put them in a little bit neater so that we can comply with the rules. And some of the examples are they may give clarifications on how you determine travel, compensatable travel time, or prep time for an employee. These are things that, can get an employer in trouble. And even if it's unintentional, you still could be held liable for large amounts of damages and attorney fees. So it's something that you want to keep a close eye on. And every year, sort of make sure there's been no changes in certain laws and wages and salary and basically employment law changes. I also wanted everyone to take notice to keep an observant eye for potential changes that are going to potentially occur by executive action. President Biden has signed an executive order where he's looking to increase the federal minimum wage to $15 per hour. So that's something to keep an eye on because it may come sooner than 2026. I'm sure that's certainly his intent to do so. So you want to keep an eye on that to make sure that you're compliant with that. Next, we're talking about exempt employees. This is probably one of the major two areas that people or employers particularly get themselves into trouble with. So exempt employers are employees which are paid on a fixed salary basis and don't usually receive overtime, okay, if they work in excess of 40 hours per week, per work week. However, what most employers do not realize is that salaried employees must fall within an exemption to be able to pay an employee a fixed salary with no additional compensation for overtime hours worked. Okay, so some examples of exemptions include administrative exemptions, executive, computer professional, and highly compensated individuals. I have a lot of company owners will say, but Regina, they agreed to this. How can they sue me on this and say that now I was supposed to pay them hourly? And how am I supposed to figure out an hourly and overtime if what our salary was based, their compensation was based on salary? And unfortunately, what I always have to tell them, and they look at me like I'm some kind of alien, literally, is that it's irrelevant what an employee actually says, does, or agrees to. If the employee is not properly exempt, regardless if they agreed to or not, to a fixed salary with no overtime, you're required to pay them overtime. And it is on the employee, it's the employer's burden to prove a proper exemption in any kind of litigation or administrative proceeding. So you cannot lay comfort in that, and it's not a defense. It's actually not a defense to these. It's not literally a affirmative defense that I can raise, or any kind of estoppel that the employer relied on the employee's agreement to receive compensation this way. The FLSA is very, very strict about these type of issues, and the burden is on the employer to prove a proper exemption. So if you're going to pay someone on a fixed salary, you want to make sure they fit within these definitions of exemptions squarely. If there's any doubt as to whether or not they're properly classified, which can be in and of itself an art form, then as a rule of thumb, when in doubt, pay an employee hourly and overtime. That is always the safest bet if you have any doubt, because these litigation cases are highly expensive and actually can include personal liability to the owners, managers, and HR directors of companies that directly supervise these employees. So this is some serious stuff. You better err on the side of caution. So next we also have, actually, just for a moment, I'm sorry, Mrs. Carbonell has actually asked a question: how long do we keep the W-9s, and which forms? Okay, so the W-9s, they must be kept at least for 3 years also. From the date in which I would calculate it from the date in which actually this says 3 years maybe for time sharing. I mean, for timekeeping purposes, for labor purposes, but for the IRS, I would keep them at least for 7 years to be on the safe side, because you're going to need to produce these 1099s anyways in the event of an audit from the IRS. So I would let the IRS rules kind of govern here, which is a longer period of time. but typically it's about 3 years from which the actual independent contractor stopped working for you, as there's statute of limitations on the ability of independent contractors to waive wages claims. So, and actually it fits squarely with our topic right now, the screen that we're on right now, misclassification of independent contractors. This is also one of the most common mistakes that employer makes. They do not realize that even though they may have, well, they're an independent contractor, I didn't have to pay withholdings, I didn't have to pay Medicare and FICA and so forth, and unemployment, the unemployment percentage for the state. And that is actually false. It's irrelevant if the independent contractor agrees they're an independent contractor. It's irrelevant if you have an agreement that states the foregoing. It's irrelevant if you paid them with 1099. The Department of Labor actually also just issued additional guidance on decision or clarifications on sort of factors to consider, which will go over new factors to consider in determining whether someone is actually an employee versus an independent contractor. So here are the factors that the Department of Labor and any judge would look into to determine if the person was the independent contractor is properly classified. If they're not properly classified, they're going to be considered an employee, even if they're considered independent contractors for IRS purposes. So part of the problem is if they're found to be employees for employment purposes, you have to pay back liquidated damages, all the back withholding taxes, attorney fees. It's a very expensive over time, and it's a very expensive endeavor. So here are some of the factors to consider whether or not someone is actually an independent or contractor or not. And it's the factors that the Department of Labor, again, and a judge will use to determine whether this person is truly classified properly. Those factors include the extent in which services are rendered as an integral part of the principal's business, the permanency of the relationship between the parties, the amount of the alleged contractor's investment in facilities and equipment, the nature and degree of control by the principal, the alleged contractor's opportunities for profit and loss, the amount of initiative, judgment, and foresight in the open market competition of others required for the success of the claimed independent contractor, the degree of independent business organization and operation between the employer and the contractor. And then the additional factors we'll discuss later on in the presentation, they're pretty much clarifications by the Department of Labor as to how to weigh these different factors in making a determination of proper classification. Often not any one factor is dispositive. The Department of Labor and the courts usually will take a look at the totality of circumstances. But I can tell you in general, there is a desire to protect employees and more sort of a presumption that most people are likely employees and not independent contractors in most cases. So you want to keep this in mind. Once again, many employers tell me, but I have an independent contractors agreement. And I continue to say to them, it doesn't matter. Ultimately, when you're in doubt as to whether or not they're an independent contractor or employee, the safest thing to do is to pay them as an employee, make them an employee, okay? Especially if you're controlling their schedule, you provide them a lot of the tools in which to do their jobs with, their degree of financial relationship with you and the interdependency on your particular job is great, the more likelihood it's going to lean towards the person being an employee and not an independent contractor. So this is something to keep in mind. Ooh, sorry, too fast. Okay. So basically next we're going to talk about time and employee record keeping requirements. This is literally in bold for this reason. Some employers are, well, we don't have timesheets. They were on a salary. The employee never asked for this. It's irrelevant. It is the employer's obligation, literally under the FLSA, to keep proper time and employee records, period. End of story. Nope. Doesn't matter if the employee is okay with no time or employee records, or if the employee never requested them or to be paid overtime in the past. You will still be found liable if you cannot determine what hours they worked and whether you paid them properly. It's irrelevant if it's intentional or unintentional. The only time in which intentional or unintentional comes into play in litigation or in any administrative proceeding is if it's intentional, you potentially can be the damages can include a third year of liquidated damages, which is sometimes treble the amount of the salary that is owed to them plus attorney fees, or some type of additional penalties they may sort of assess, right, depending on what kind of proceeding you're in. So that's the only difference. Otherwise, even under unintentional failure to keep timekeeping records, or be able to determine really how many hours that an employee worked, you're basically going to be liable to that employee. And good luck trying to determine what they actually worked. Often these employees will say they worked 120 hours each week for the last 3 years. And you say to yourself, wait a minute, you can't physically work that many hours. So I can show they're a liar. I can show that this is fake, and I can show all of these things. And some of that, the credibility always always plays into, any, changing and determining the outcome in certain litigations, you know what I mean, of the other party. However, most of the time, these employees are judgment proof, can't be sued if they're found to be lying, and it's very hard to prove it, because even with videos, well, they made me turn off the video, or they're not producing the video showing that I came back after I clocked out. You'll be amazed at how creative some of these employees can get. So then it's a determination, even if a juror finds that you owe them 1 hour and they're requesting 300 hours of sort of overtime pay, or, additional hours they were not paid. If you owe them 1 hour, you are liable, and you're liable to pay for all of their attorney fees. So as crazy as that sounds, that's how crucial and difficult these type of litigations can be, and they're highly expensive. Again, these are the type of litigations that can also lead to personal liability of owners, business managers, and HR directors, anyone basically who had supervised the employee. So it's just better not to take these chances. And I find that most employers that get sued, though you can be sued even if you have proper timekeeping records, are the ones that have no timekeeping records, because the employees go to attorneys and they realize, ooh, this is a good one. This is low-lying fruit here. The employer is going to have a hard time actually defending itself. So then you unfortunately have issues where they start to dig in, and litigation becomes more protracted, and unfortunately often more lucrative for attorneys to keep protracted litigation so they can run up their fees. It's a shame to say that, but unfortunately it does happen. And in Miami-Dade County particularly, we're one of the #1 counties and districts in the country for these type of lawsuits. So it's imperative that employers do whatever they can to protect themselves. And I'm going to teach you a couple of different ways in which that you can do so. First is I want to define, just so that you understand. I know it's very small. I can give this presentation to everyone afterwards. I just wanted to put it on the screen. This is what the FLSA requires, the Fair Labor Standard Act, that pretty much governs all employers with any kind of connection to interstate, which pretty much means almost every employer. I have yet to find an employer that's not included. It's rare, let's put it that way. So the FLSA requires for every employer to keep these following records. It doesn't say it has to be in a specific format or a specific program, but these are all the different factors in which you have to have in an employee's file, and in order for them to find that you've kept proper time records as to the employee's hours worked, their commission. How did you determine if it's not straight sort of hourly punch in, punch out? How did you determine how many hours they worked? Did they have travel time? Did you compensate them properly for that? Did you compensate them properly for prep time? It can actually be more complicated than it looks if you don't have just a straight 9 to 5 employee. Even meals and breaks can become complicated if they're not properly records kept of. So, where an employee clocks in and clocks out for lunch, for instance, or breaks. Particularly Florida doesn't require a lunch break per se, but obviously I encourage, as an employment lawyer for employers, always offer these types of benefits to their clients, or breaks, because the employees do need it. And you do want to attract employees that are appreciative of that and treat them well as well. Hopefully they will treat you well back. In most cases, I find that's the situation, with the exception of a couple bad apples. But in other words, but if they do take a break, let's say, for instance, that they're not completely relieved of their duty, it is important that the employer actually pays them for that time, because that's not really a proper break. So this area of law can become extremely nuanced and very fact intense. But I wanted to give you an idea of at least the basic, what the actual act requires you to keep. There's probably additional things that you should keep in an employee file that we'll talk about a little bit later. But I want you to have a list of what at minimum you should be keeping track of. There are also, it's important employers know that there's also other federal agencies that have separate record keeping obligations that you should be aware of, if applicable to your company. So you might be in a particular industry or like the medical field that requires HIPAA policies and privacy policies, and requires, for instance, that your employees sign certain documentation to keep the information private. There are other industries also that have higher safety regulations, and in which case they may have additional record keeping obligations. And I'll talk to you a little bit about, for instance, insurance, even for insurance purposes, although that's for private sort of industry, that's for your insurance company. There's additional record keeping that you should probably always have on file. I'm a big advocate of record keeping and documenting things and memorializing things as they occur. It's usually very helpful for litigation purposes and lends itself to additional credibility for an employer. Also, you want to keep in mind on state and local laws actually can have additional record keeping obligations. These would be in addition to those posed by federal law. Some people are surprised to hear that Miami-Dade and Broward actually have separate ordinances, rules on jury duty, equal pay that are actually in addition to the federal laws. So they're usually a little stricter. They add additional provisions to what the federal law requires. So you really want to be aware of that. Not all cities have them, but usually large cities with large populations usually have additional rules in order to protect their employees. Horror story. I have probably many I can give you. I've kind of given you a little bit of an idea of what can happen in these type of litigations. So employers are always surprised and they say, oh, this person, I gave them, I can't believe they're suing me. They said they were okay with a fixed salary. I never made them work over 40 hours a week. How can they say that they worked, 90? That's impossible. My office is, my company's not even open during those hours. How can this be? It's clearly they're a liar, and she did this, and we had just recently accused her of stealing this, so we think this is retaliation. And they come up with all these different things that normally would be very compelling in litigation, to kind of show whether there's reliance on someone's agreement to enter into a certain pay arrangement or a certain type of contract between each other, obligations, or there might be credibility issues where clearly you had the right to fire this person because they may have sued, or you might have terminated a relationship with another company because of their behavior. Employees, it's a different situation. A lot of times I will find that employees all of a sudden will say, well, they fired me because I just complained about not getting paid overtime. And they never talked about overtime. And there's no requirement that they put it in writing. There's there's nothing. It's really on the burden of the employer to pay them properly. So you say, how can this be? Everything just points to this basically being a scam or just sort of a legal blackmail. And unfortunately, I then have to proceed to tell employers the basic reality of these cases. There's very limited defenses to these type of cases. Basically, payments, statute of limitations if it's beyond 3 years, or if it's 2 years for unintentional behavior. There's just not many defenses to this, even if it's unintentional. And the employee is lying. These cases will go to trial because it's an issue of fact. They can't even be usually dealt with on a motion for summary judgment. And many times the employer and the jurors may not believe them, but if it's not clear from the time records, whether you owe them an hour because you didn't have proper time record keeping, or you owe them 300, the juror may agree that, their credibility is poor of the employee, and in which case, but they may discount a lot of what they may be saying that's exaggerated. However, if the employer can't prove it and there's a question of doubt, the juries come back, even if you owe them an hour of time and it was unintentional, you are going to be required to pay all of that employee's attorney fees, which in most cases is 20, 30, 40, 50, 60, 70, 80,000, 100,000, 200,000. These cases can get really, really crazy with the amount of attorney fees that the plaintiffs can run up. And that's in addition to your attorney fees. Often these employees and these employee lawyers, they'll include the owners and HR directors and managers personally in the lawsuit. And they say, well, Ms. Campbell, then maybe we need to go out of business. I can't afford this anymore. You can go out of business. But at the end of the day, if they obtain a personal judgment against you as an owner, that's going to follow you around. And most of the time, employee obligations, sort of like hourly wages, is even non-dischargeable in bankruptcy in most circumstances. So this is not something somebody can say, wow, I'm just going to have to close shop. I can't afford this. Unfortunately, it's going to keep following you around. And the employees and the employees' lawyers know this. They understand, unfortunately, instead of this law being used as a shield to protect employees, as was needed, early in the 19th century when this was sort of implemented, it's become a sword for many employees. And unfortunately, a significant detriment and liability for employers that have to keep an eye on and try to mitigate this damage, this potential risk for. So what I tell you is a little compared to what I've seen. And most of the time, I literally have to tell my clients, they look at me like I'm an alien, and that can't be right. That can't be right. And I say, seek a second opinion. Unfortunately, these are how these cases go. And I try to encourage them, actually, not in every case, but a lot of cases, to settle early on, because ultimately it's going to come down to a very difficult situation for employers, depending on the facts, basically. But again, most of the time where I see these type of litigations is where employers did not keep timekeeping records. So it's a free-for-all, basically, to try to figure out what the employee actually did and what hours they actually worked. One source of area also that becomes hard is remote workers or truck drivers. It's, they're out on the road. You're not seeing them all the time. You're not seeing if they take a lunch. Do you have a lunch policy that requires them to take lunch from a certain period of time? How did you know they were taking it? A lot of times there's no policies in place to refer back to, which is, again, a detriment to the employer, which is why I'm going to explain to you a little bit, indicate to you several documents and agreements that are absolutely essential for every employer shortly, which comes now, basically. So here are essential employment agreements and documents. Keep in mind that this is generally what every company would need. There could be specific agreements and documents that your company needs if they're sort of a special industry or have special circumstances. But I highly recommend employment agreements, that particularly state at will. And the only way that your employment status at will can change is, let's say, for instance, the president signs off in writing to change your at will sort of status. That way you're secured that the employee can't say, well, my boss said I'm doing so good, they'll never let me go. And they took it as sort of an employment arrangement to never be able to fire the employee. With clear directions as to how status and provisions and assumptions and obligations can change, helps the employer sort of enforce these agreements, and it gives a baseline, basically, that there could not be misunderstandings or any oral changes of employment status based on something that happened day to day that the employer or the president is not even aware of. The other thing I highly recommend when possible, and usually it's usually needed, termination or release agreements. So when an employee leaves, there really should be done an exit interview, by HR or their supervisor. Why are they leaving? I mean, obviously some things are obvious. They're leaving because they were either fired or they might be retiring or, deciding just to stay home and work, whatever the case may be. But we want to make sure we understand why the employee is leaving. And if they have any concerns, are they concerned that they weren't paid a particular check, or they were shorted somewhere, or they were being harassed and they can't take it anymore? We want to know the reason why it's being terminated. Even if you terminate them for cause, it's probably important still to try to, get a termination or a release agreement, and there has to be some kind of consideration. So you have to think about when you can do that. Certain termination for cause sort of situations cannot lend itself to that, but you want to consider the use of these type of agreements so that you can limit your liability and end it right there, so they cannot come back. Now, there are certain claims that you cannot limit in termination release agreements, which is some certain federal claims, whistleblowing, workman's compensation, and equal protection sort of act. You can't really release them unless the case itself was about those type of claims. So the other thing that is extremely important for employers are employee handbooks and/or company policies. Employee handbooks will actually have many of the policies, company policies in them. So, but if you do not want to endeavor to do an employee handbook that's sort of more comprehensive and has a lot of different policies, maybe you're a smaller company, you definitely want to have some standalone policies together. And on the next slide, I'm going to talk a little bit about what are the type of policies you should have in a handbook at minimum, and/or standalone policies. So basically, you need to have, some kind of policy. If you don't have it in an employment agreement, that the at-will employment is that it's an at-will employment. Okay, to make that very clear. Once again, with strict provisions as to how to override the presumptions of an at-will, employment. You want to have a wage, compensation, and benefits policy. So this may seem sort of obvious, but you want to describe what, if the person's non-exempt, how they're going to be treated and how the pay structure goes. If they have commissions, if they have additional sort of bonuses that are, even if they're discretionary or not, you want to be clear what it is that you're going to be providing for each employee and how they can be eligible for those type of wages, compensation, or benefits, depending on what benefits the company decides to offer. But at least there's a clarity to it so that employees can either ask for it or they know what they can get, and they can't then later claim that they're entitled to more because the policy is clear that this is what non-exempt employee is going to get. These are the type of benefits non-exempt or exempt employees are going to get. So it just adds transparency. Also, time off policy. Clearly, delineate what that policy is going to be, whether it's paid time off, vacation, sick, personal, and how to use this time off. That way you don't have employees trying to say, well, my supervisor's harassing me because I asked him for time off and she gets mad when I'm doing this. Or he gets mad when I'm asking for time off, and I think they're discriminating against me for asking for time off, even though I'm allowed to receive time off. But, if you look further, it might be that the employee is telling their supervisor the day before they want the time off. Maybe that's not appropriate, and it's not something that the business can sort of work in. It's not, it doesn't work for the business, for the company. So if you delineate policies that just say, you have to ask, absent an emergency, obviously, sick, you can't really tell them you're going to get sick, but vacation and time off and personal time, you may want to delineate what they have to do. And even when they are sick, what's the procedure? They have to call their supervisor at least by a certain time of day, the day in which they're sick, or they have to ask for time off at least a week in advance, and it's subject to the company's needs, things of that nature, so that it's clear. So when you go to enforce the policy, there's no, well, Johnny said and Susie said and everyone does it differently. It is this way. Absent and tardy policies, absence is kind of time off depending on the circumstances. You also want to make sure this is clear. What are they supposed to do with tardies? When they're going to be tardy, what is the procedure for them notifying the employer? Okay. Discrimination and reporting policy is very important to have this in place, and clearly what an employee is supposed to do if they're suffering from discrimination. Safety policies and procedures, same thing. What are the procedures and what are the safety rules and procedures they have to follow, and how do they report somebody that's not following them, or potentially report a dangerous situation? You want to have that very clear, particularly how to also report a workman's compensation claim. Okay. Harassment policy, same thing. Clear policies and procedures on how to report it and what's acceptable and not acceptable. And each one of these circumstances, discrimination and harassment. Disciplinary policies, how the company is going to act and when they have to discipline an employee. If it's tiered, then okay, first time is a written warning. That written warning should go into the employee's file. Second time might be a demotion or a reduction in salary. Whatever your policy is, you want to have it clear. Property, computer, and data ownership policy. This is also something you want to have clear. This is a company's property. This is a company's data. Under no circumstances can an employee use it for any other purpose other than for the scope of their job. Okay. Drug and violence at the workplace policies. This also can encompass potentially domestic violence sort of procedures. If one of your employees are concerned about their significant other coming in and committing violence against them. This would also cover violence on employee on employee. And what happens if you are using drugs? So what is the company's policies on drug use while being, obviously not while they're being employed is really the important thing, but the important thing is drug use while they're being employed, while they're working, because that could create a dangerous situation. Keep in mind that there are other special industry types of policies also that need to be set forth in this company policies or handbook, which might include the medical and legal industry. Site policies like HIPAA, privacy, policies, confidentiality, requirements. Also consider posting OSHA, FLSA and workers' compensation posters and notices. Very important to do that. Put that in work areas. And then here I've indicated what some of the most important things, and take into consideration all of these policies. Your company should apply all of these policies and procedures equitably and evenly across all employees at all times. So in other words, you can't you got to be careful that you don't apply these policies sort of differently to different employees, to secretaries, to managers. They should be evenly, if they're able to be evenly applied and equitably applied, they should be. If you deviate from these policies for any reason, it should be clearly noted and documented with witnesses why you might have deviated into these particular circumstances. If not, it's ripe for employees to say, hey, listen, they didn't follow their policies with me. You know, with Johnny and Susie, they did this exactly like the policy with me, they did this. And therefore that shows discrimination or retaliation because I had complained about something else in the past. So you want to try to avoid that and be equal and equitable, you know, in application of all your policies as an employer. So the other thing here, other essential agreements for employers include non-disclosure agreements, non-compete agreements, confidentiality agreements, and independent contractor agreements. These are very important. I mean, of course, the first three are particularly, you know, concerned with protecting, you know, your company's the company's assets, the company's goodwill, the company's client base, the company's data. You're trying to protect the company from employees going improperly competing with this information that might be, you know, commercially sensitive to your business. You don't want them taking it to compete against you. So those are agreements that are, you know, usually very important to protect employers. Also, independent contractor agreements. When, you know, if you are going to have an independent contractor, hopefully they're properly classified. If not, you know, in either case, if they are going to be classified as an independent contractor, there should be independent contractor agreements that sort of set forth the rights and the scope of, you know, of what the services are going to be that the person is going to give. The fact that they are responsible for their own, you know, taxes and so forth. They need to carry liability insurance, that they're not considered employees. Also, maybe even a provision that indicates that if it turns out that they are considered employees, provisions as to how the employer is going to react, or any shared liability as far as what wages are going to be sort of the prevailing wage in those circumstances. Some courts may strike down that type of provision, but in some cases, depending on if it's reasonable, it may be upheld and it may be helpful to help you when you've misclassified an independent contractor. I'm going to try to move along a little bit because I know it's a quarter till and I wanted to give some time for questioning. This is a very important slide. I had basically discussed it a little bit before also in the webinar, mitigating employer liabilities and risk. So it's very important to help an employer mitigate the risks. These are a couple of points that they need to do. I mean, they need to manage employees' risk and liabilities. So a couple examples and a way to do that is compliance with local law, local, state, and federal laws. We talked a little bit about how it can change, and employers should be checking this annually to make sure that they are complying with everything that applies to their particular company and within their industry. Also, to help manage employee risk and liability, the implementation of proper policies, procedures, and agreements, including robust timekeeping records, along with performing audits every year of your employees' wages and classifications to ensure that, and in your employee policies to make sure that they're being equitably applied. So an audit of sort of employees' wages and sort of a review of the employees' policies to make sure that they are being implemented properly and evenly, so to speak, and consistently. Also ensuring that all third-party relationships are being properly managed in order to avoid potential classification of your company as a joint employer. People don't realize that they can actually, companies don't realize that if they hire an employee leasing company, or they have some type of sort of joint venture with another company that sort of manages employees, but the employees, you as an employer have some benefit and control over those employees, including the employee leasing company employees, you could be considered a joint employer. So if that other company is not properly paying their employees or subject to employment law claims, the employee can bring you in as a joint employer. So these are kind of things that you want to keep an eye on, these type of relationships, to make sure, and if you do have them, make sure they're properly managing and abiding by all employment law laws. Otherwise, you could be in trouble yourself. Okay, so this is also consider limiting liability based on employees' actions. So in other words, remember, consider, you know, if you have a driver, make sure that you've checked them to make sure they don't have a lot of tickets, driving tickets, maybe speeding tickets, perform background checks to make sure they don't have anything in their history that might sort of disqualify them or indicate that they are not able to perform certain duties without potential, without harming the employer or somebody else, because they have a history of, again, reckless driving or maybe reckless behavior in some manner that's similar to the services they're providing for the company. Removal of employees from dangerous duties. upon notice and reoccurrence of risk and or danger. Also, you need to make sure that you're properly supervising all your employees. You can't, if you haven't noticed something that an employee is doing for long periods of time, you're likely to be held more liable for their actions, even if they're outside the scope of their work, because you should have noticed that they're sort of behaving in a certain manner that's not consistent with their job duties. Also very important, once again, know what laws apply to your company. Often employers, particularly those in the growth stages of their business, don't realize that as they grow, their number of employees grow, and as their employees grow, they may be subject to additional laws based on the number of employees that they have. So in the next slide, I give you a couple of examples of this. So basically, number of employees that you have. Then, for instance, when you get down to 15 employees, Title VII and the ADA is going to start to apply to you. Okay, so this is something you want to be aware of. You may not realize, great, I'm growing, we're doing fantastic, but now additional laws are applicable to you once you've reached this amount of employees. 20 employees, you're going to start to be covered by the ADEA. Okay. When you get to 50, the FMLA, the Family Medical Leave Act, is going to be applicable to you, although it's a little bit trickier on the determination of 50, but for the most part, when you're hitting 50, you're more likely, 50 full-time employees, you're more likely going to be subject to this act. 100 employees, this is it's going to trigger, if you have to have a sudden layoff of many employees, then you are subject to the WARN Act. Okay, so this is just something to keep in mind, and you should, as you're growing, your HR department should be, kind of constantly on top of the policies and make sure you guys are compliant with everything as much as possible. Once again, as you can tell, compliance with all local and state and federal laws is very important, particularly in employment law, because there's fairly strict liability for employers, and then they're required to pay attorney fees when they, violated certain, most laws. So it's something to keep in mind. So you must be familiar with all local, state, and federal laws. Some states, cities, and counties have heightened insurance requirements, such as those for workman's comp. So depending on the city that you're in or the county you're in, they may actually impose additional workman's comp requirements depending on the type of company that you're in or the industry that you're in, particularly heavy industry or construction industry. They may be more stricter about the amount of policies that you have to have and when your employees are required to be covered. So you want to keep an eye on that. Also, other ways to help you mitigate insurance, risks and liabilities, and I think is sort of necessary insurance policies for employers include employer liability policies, which will help you with wages and type of retaliatory type of claims, E&O policies, and general liability that cover employees, and specifically stuff employees that do activities that employees do in their own car. Sometimes you might say to them, please go drop this off at the mail, at the post office. They drive their car there. God forbid they get into an accident on the way there. It's technically within the scope of your employment. And it's not, without this type of policy that covers that, the employee's insurance may decline coverage because it was within a scope of an employment activity. So these are the type of things that can just help us limit, we can never entirely remove risk or liability, but we can certainly try to mitigate it. Then here, there's some new changes I'm just going to bring to your attention very quickly. This happened actually January 1st, 2020, but a lot of people have seemed to miss this. There's a new threshold salary for exempt employees. So previously, depending on the circumstances, you had to pay exempt employees a minimum of $450 per week. Now that has jumped to $684 a week. Okay. If any exempt employee makes less than $35,568, you must pay them overtime, period. Okay. It doesn't matter. They can no longer be exempt is basically what they're saying. Okay. The new rule does not change the duties test requirements. So it's still the same description to qualify for the exemptions themselves are relatively the same, with the exception of opinions that are given and kind of adjust the exemptions. They clarify in certain circumstances how to apply the exemptions. Also, the annual compensation for highly compensated employees, it went from a minimum of $100,000 per year to $107,432 per year. Note that you still have to meet the minimum requirement of $684 per week as a minimum salary for highly compensated employees. What does that mean? It means that potentially their commission or some kind of bonus has to make up the difference to bring them up to $107,432, but they have to minimally be paid $684 a week. Okay. Below you'll see employers are also allowed to use up to 10% of their non-discretionary bonuses and incentives and commissions to satisfy the standard salary threshold level for highly compensated individuals. Finally, there are additional rules that apply to workers in the motion picture industry and U.S. territories. I haven't really gone through them. It's sort of a niche area, very specific area. Most people are not involved in those industries, but just to let you know that it has also changed if you happen to be. So new rules, also clarifications on employees versus independent contractors under the FLSA. This takes effect March 8th, 2021, unless otherwise delayed. The reason why I say that is often these rules and the implementations or effectiveness of the dates of these rules change because they get challenged or someone kind of comes back and they have additional comments and they decide to postpone them as it goes through the administrative law process. But it's important for you to know that the Department of Labor on January 6, 2021 announced its final rule on clarifying the standard for employees versus independent contractors under the FLSA. So what does this mean? The final rule basically reaffirms the economic reality test when you're weighing if someone's an employee versus an independent contractor. So again, they kind of look to see whether the individual is in business for himself or is economically dependent on an employer. So if you have an independent contract that's working for you, 30, 40 hours a week, and they really don't have much time to work any other type of job or project, the more likely that they're going to be considered an employee under the FLSA. It also identifies two core factors that are most probative to the question of whether or not the worker is economically dependent on someone else's business or himself. And those two factors include the nature and degree of control over the work and the worker's opportunity for profit and loss based on initiative and or investment. Okay. They also identify three other factors that may serve as additional guideposts, particularly when the two core factors we just discussed above do not point to the same classification. So it's sort of another level of analysis. And they say, look at the amount of skill required for the work, the degree of performance of working relationships, between the worker and the potential employer, whether the work is part of an integrated unit of production, and sort of whether the actual practice of the worker and the potential employer is more relevant than what may be contractually or theoretically possible. That's why I tell you it doesn't matter what a contract says. It actually matters what the employee or independent contractor actually does in determination of the classification. So there's also various new safety rules and amendments that have recently come out due to COVID. You should keep an eye on that depending on the industry that you're in. It's highly voluminous, and the OSHA rules and other agency rules they go by industry and company. So if you need more information on that, it's recommended that you consult with an employment law attorney to specifically find out what applies to your company. So finally, and I apologize, it always goes longer than I expect, but we have questions and answers. So if anyone has any questions, someone has a question. Okay. So Mrs. Carbonell again, what if an independent contractor has signed an agreement of non-disclosure and non-compete, but these forms state employee? Okay. So this is kind of where you end up in a situation where what was really intended in the contract? There's a contract language problem here. But I think ultimately, okay, so I guess let me take a step back. What's going to happen is ultimately the independent contractor agreed to a non-disclosure provisions and non-compete provision. The fact that they're stated as an employee for purposes of enforcing the contract, the courts probably would not find a distinction unless there's something in the agreement that falls by defense. In other words, you didn't pay the independent contractor or there's other defenses to non-compete or non-disclosure that are operative, right? The courts are not likely to get hung on the fact that you use the word employee. The fact that they may actually ultimately be an employee versus an independent contractor, maybe under labor standards, right? Labor law should not affect actually the fact that they are required to comply with the terms of the NDA and the non-compete. Not usually. Again, specifically, it depends on the circumstances of a case. There might be a situation where the facts of the case lend to a defense to those type of agreements. But it's for other purposes. When I think about this, you want to be careful because independent contractor agreement from a labor point of view might point to what you guys actually intended if the person was an employee. So someone can use it for you in an employment wage claim as evidence that you guys really intended for this person to be an employee or there was confusion. So a smart, plaintiff's counsel is going to try to twist potentially the agreement to show that you guys really intended for this person to be an employee. But from a purely contractual point of view, as far as enforcing the NDA and the non-compete, most courts are probably likely to uphold them. I don't know if I answered your question or not. Maybe. Okay. It's sort of a weird vehicle because I feel like I'm talking. I don't see people when we talk back, so I apologize if it's gets to something getting used to. But hopefully I've answered your question, Ms. Carbonell. Okay. It looks like yes. She says yes. Okay, great. Fantastic. Does anyone else have any more questions? Everyone's a little shy. Okay. Well, Alejandrina, no, thank you so much for the information. Okay. So if there are no more questions, I do want to invite everyone, and let me put it back up on the screen to let you guys know. We do have, want to invite everyone to our next webinar, should be in March. It's going to be 7 essential qualities of a forward-thinking company. A little bit more towards the business sort of acumen and sort of thoughts about what makes, the qualities of a forward-thinking company and what helps companies evolve, and characteristics of successful companies in the past, and what we believe will be helpful from a legal point of view for a company to be successful as well. We have the register link here. I can send this presentation to everyone as well. If you also would like to be part of our newsletter, blogs, or webinar, please text Campbell to 22828. Or you can come visit us on any of our social media sites. We'd love for you to become a follower of ours. Or if you have any additional questions, reach out to us. And in light of Valentine's Day, here's a little happy Valentine's Day to everybody. Let me see if there's any more questions. I think everybody is good. Wonderful. Glad to hear. Well, everyone have a wonderful weekend, and I hope you have a great Valentine's Day. And and thank you for attending. Appreciate it very much. Thank you.